Hi students, welcome to the Shorthand Hub channel. This is Harinaganand Idumudi, instructor of Shorthand. For all Shorthand grades, I am offering legal and general dictations. For the Shorthand subject, I am conducting both online and offline classes for the students. This dictation passage link and other crucial links are given in the description box. Anyone interested in joining the Telegram group can do so by clicking the link provided in the description box. Small note. Grammar locks, contractions, special contractions, phrases, advanced phrases, and a special list of words needs to be written once in every 15 days, and then only you will get a better speed in stenography. Get ready for the dictation on the topic of legal subject. Ready? 1, 2, 3, start. It is contended by the learned government pleader while reiterating the pleadings in the affidavit filed in support of writ petition that the questioned order passed by the tribunal is highly erroneous, contrary to law, and opposed to the very spirit and object of the provisions of Andhra Pradesh Civil Services Classification, Control and Appeal Rules 1991 and the Andhra Pradesh Civil Rules Conduct Rules 1964 in general and Rule 3 Class 4 in particular. It is the further submission of the learned government pleader that without there being any proper authorization from the superior authorities, the applicant herein submitted a letter dated 24/7/2015 proposing allocation of the employees between the state of Andhra Pradesh and the state of Telangana in the ratio of 50-50, contrary to the earlier letter bearing number PAO/admin dated 15/4/2014, wherein the ratio of 20/80 was proposed between the states of Andhra Pradesh and Telangana. It is further submitted by the learned government pleader that in view of the said action on the part of the applicant, there would be lot of financial burden to the state exchequer. It is the further submission of the learned government pleader that without properly considering the said aspect, the tribunal allowed the original application filed by the applicant first respondent herein. On the contrary, it is the contention of the learned counsel for the applicant first respondent herein that there is absolutely no error nor any infirmity in the impugned order, and in the absence of any justifiable grounds, the questioned order is not amenable to the judicial review under Article 226 of the Constitution of India. It is the further submission of the Land Council that having regard to the findings recorded by the inquiry officer during the course of inquiry with regard to the letter dated 15/4/2014, in the absence of any signature on the same, the tribunal is perfectly justified in passing the impugned order. It is further submitted by the Land Council that at the time of allocation, the first respondent herein participated in the first 2 meetings, and subsequently one person who was holding the officiating post of pay and accounts officer at the time of final allocation was appointed as the presenting officer. It is the further submission of the Land Council that having regard to the cogent reasons assigned by the tribunal, and in the absence of any jurisdictional error or the element of perversity, the writ in the nature of writ of certiorari cannot be issued. In the above background, now the points that arise for consideration of this court are whether the order passed by the Andhra Pradesh Administrative Tribunal allowing application filed by the first respondent herein is sustainable and tenable, whether a writ in the nature of writ of certiorari can be issued in the facts and circumstances of the case. The Andhra Pradesh Administrative Tribunal, on the basis of the pleadings and the contentions advanced on behalf of the applicant and the authorities, framed the points for consideration. While dealing with the issue of allocation proposed by the applicant herein, the tribunal recorded a categorical finding that the subsequent officer by name B.L. Hanumantarao, who stepped into the shoes of applicant as in charge PAO and who was appointed as presenting officer in the inquiry initiated against the first respondent herein, proceeded with the proposal of the applicant first respondent at the ratio of 50-50, and the tribunal also noticed the fact that no action was taken against the said B.L. Hanumantarao. It is also required to be noted, as pointed out by the Land Council for the applicant's respondent herein, that In the inquiry report, the inquiry officer, while appreciating the evidence in paragraph 6 of the report, categorically observed that the letter number PAO dated 15/4/2014, wherein the ratio of 2080 was shown, doesn't contain any signature of the concerned. The tribunal also, at paragraph 10, class C and D of the impugned order, while noticing the letter dated 15/4/2014, categorically recorded a finding that neither during the course of hearing nor in the counter affidavits filed by the respondents, the said aspect of decision of the government for allocation of staff at the ratio of 2080 was traceable. Stop. If you want to get more updates, please subscribe our channel. If you really feel that this dictation can help you in the competitive examinations, click the like button, share the video and make a comment. We are also making this passage available to you in 80, 100, 120 and 150 words per minute. I am conducting both online and offline classes for the students. Those who want to join the Telegram group can join through the link given in the description box. Thank you.